our brown bag on the new regulations that were passed in July. As you know, there were some changes to 1614 that will go in effect at the end of September. And today we're going to outline what those changes are, what they mean, give you a chance to do a Q&A so that you can get some of your questions answered. We had a handout that was passed around. It's a basic document with the Q&A that's on our website. So if you didn't get a copy, just show me your hand if you don't have a copy of the handout. Just Todd Denikoff? Okay. I am Dexter Brooks. I'm the Director of Federal Sector Programs within the Office of Federal Operations. I'm here today to introduce you to our distinguished speaker. He's a panel of one. His name is Gary Hozempa. He's a senior attorney in EEOC's Office of Legal Counsel. EEOC, we're so heavy with attorneys. We have an Office of Legal Counsel. We have an Office of General Counsel. And then every other office stacks their staff with attorneys as well. So, but Gary is works in our policy and guidance office. He actually deals with a lot of regulations. I was joking with Gary earlier today. He was involved when we changed the regs from 1613 to 1614. Gary was one of the folks who worked on that. The 99 regulation change. Gary worked on the no fear regulations as they were implemented. He knows federal sector regs like the back of his hand. So usually when I have a question about what do we mean when we said this in the reg, I normally will go to Gary. So I feel honored to have him as the presenter today. And with that, I'm going to turn it over to Gary Hozempa.
Yeah, no, use it. Yeah, it's good. No, keep it on. Okay. Thank you, Dexter. Everybody hear me okay? Welcome. Thank you for coming. Thank you. You know, when I was, as Dexter said, well, let me just give you a brief history of my employment at EEOC. I started here in June of 1979, and the first office I worked in was called the Office of Review and Appeals, and that office is the predecessor office to the Office of Federal Operations. And I worked in that office for 11 years, so I was writing and drafting appellate decisions for that 11-year period, and then I transferred to another office after that. But that's where I started, and it's very close to when EEOC first was given authority to oversee the federal sector complaint processing procedures and system. And as I was preparing my presentation this afternoon and thinking about the revisions we've just made to 1614, I was thinking, you know, it might be beneficial to put it all in context by giving you a very short historical presentation of where and how this whole system began. But I don't want to do that if everybody knows that. So, can anyone here tell me when, how the federal sector process first began? Dexter. Yes.
Oh, I can answer?
Yes. Can you use the mic?
Oh, you want me to say when did it first begin?
Yes.
Because I want to see if your answer is the same as mine.
All right. Dexter wants to see if we're on the same page with the answer.
You said the process?
The process, is that on?
Okay.
Yeah.
Now, when you say process, what do you mean?
Well, I mean when
See, very much attorneys.
Complaints could be filed, agencies would investigate.
I would say, this would be my answer, I would say when President Truman passed Executive Order 9980, created a system that went to the Civil Service Commission for review of decisions made by agency heads on issues of complaints. So,
and Dexter,
July 26, 1948.
That's right, and Dexter would be correct. This system, or some semblance of this system, has been in existence for a very long time. And so I just want to talk briefly about it so that you can get a sense of, for example, you might ask yourself, you know, where did this whole thing about counseling come from? Why do we have it? Or why is it that an agency can issue a decision about whether it discriminated against one of its employees? Why is the system set up that way? And it all began, well, as Dexter said, but it became a little bit more formal with the passage of the Civil Rights Act of 1964. And in Title VII of that act, Title VII prohibits employment discrimination on the basis of race, sex, national origin, color, and religion. and it was made applicable to employers of 15 or more employees. But the definition of employer explicitly excluded the federal government, its agencies, and its corporations. So the federal employees weren't covered, except for this very small provision in the 1964 version of the Civil Rights Act, and it stated as follows. Let me just find it. Okay. There was a provision that said it would be the policy of the United States to ensure equal employment opportunities for federal employees without discrimination because of race, color, religion, sex, or national origin. And it authorized the president to use his existing authority to effectuate this policy. So at the time, President Lyndon Johnson was president. In 1965, President Johnson signed Executive Order 11246. And this executive order prohibited discrimination against civilian employees of executive agencies and prohibited on the basis of race, color, national origin, and religion. And you would say, well, what about sex? And I don't know why sex was not included as a prohibited basis in that executive order, but it was added 2 years later in 1967 through another executive order. And just for your information, disability and age were also added, but not until 1978 through Executive Order 12106. Now, when President Johnson signed that executive order in 1965, he authorized the Civil Service Commission to implement a complaint processing procedure in order to carry out the provisions of his executive order. Now, how many people here are familiar with the Civil Service Commission? I'd say, gee, maybe 10, 15%. Show of hands, because I'm just curious. How many people worked for the federal government when the Civil Service Commission was in existence? Well, more than I thought. I'd say there's about 8, 10 of us. I can raise my hand because in the mid-'70s, I worked part-time at the Federal Trade Commission while I was a student. But when I came to the commission, there was no Civil Service Commission, and I'll explain how that came to be. Anyway, he gave, as I was saying, President Johnson empowered the Civil Service Commission to carry out his executive order. And what the Civil Service Commission did is 1 year later, in 1966, it created a set of regulations. And you can find these at 5 CFR Part 713. They don't exist anymore, but in case you're curious, you want to go see what they look like, that's where you can find them. 5 CFR Part, someone asked what it was. It's 5 CFR Part 713. What the procedure that the Civil Service Commission came up with was a person who believed they had been discriminated against would have to file a complaint against the agency alleged to have engaged in the prohibited discrimination. The agency would then conduct an investigation of the complaint. The agency would then offer the complainant an opportunity to have a hearing. The agency would then issue a final decision on the merits. And that final decision would be appealable to the Civil Service Commission. So that's how the system existed as in '65, and as you can see, a lot of those elements that existed then exist now. 2 years later, well, the regulations came out in '66. 2 years later, President Nixon, or Richard Nixon, is elected president, and in 1969, President Nixon issues Executive Order 11478. And that executive order orders that, quote, agency systems provide access to counseling for aggrieved employees and encourage the resolution of employee problems on an informal basis. And the executive order also gave the Civil Service Commission additional oversight authority so that the Civil Service Commission could now, quote, review and evaluate agency program operations periodically and obtain such reports from agencies as it deems necessary, unquote. So as a result of this executive order, Civil Service Commission amended its 713 regulations to allow for counseling and informal resolution. So now you have a system, complaint processing system that includes counseling, informal resolution, filing of complaint, investigation by the agency, hearing, final decision by the agency, appeal to the Civil Service Commission. So if you're wondering where counseling came, it came from President Nixon. 3 years later, we have Congress passes the Equal Employment Opportunity Act of 1972. And what that act did was it amended the Civil Rights Act of 1964 by adding Section 717 to Title VII. As you know, Section 717 is a section which now gives statutory protection to federal employees from employment discrimination. If you go and read 717, it says very little about what a complaint processing system should look like. There is only one criteria, and it states that an agency must take final action on a complaint with notification of its determination to the complaint. So by statute, agencies have the right to issue a final decision on any EEO complaint that is filed against it. And since it's by statute, that's not something you can take away through regulation, unless you amend the statute. The other thing that 717 did that hadn't existed prior to that was that it gave federal employees the right to pursue a civil action if they were dissatisfied with the result of the administrative process. So they get their final decision from the agency, they can appeal it to the Civil Service Commission. If they don't like that result, they can go to court. Excuse me. And the authority, again, to oversee this process still resided in the Civil Service Commission. But if you read the legislative history of the Equal Employment Opportunity Act, there are a number of iterations where Congress considered transferring that authority to EEOC. But in the end, they decided not to do that. Instead, decided to keep it where it had been since 1965 with the Civil Service Commission. The next big event occurred in 1978. In 1976, Jimmy Carter's elected president, And in 1978, Congress passes what is called the Civil Service Reform Act. And what the Civil Service Reform Act did was it abolished the Civil Service Commission and instead created 3 new agencies. Office of Personnel Management, which now had the management responsibility for personnel rules that the Civil Service Commission had. It created the Merit Systems Protection Board, which now was to do the adjudicatory functions that had previously been done by the Civil Service Commission. And it created the Federal Labor Relations Authority. At the same time that the Civil Service Reform Act was passed, President Carter issued what's called the Reorganization Plan Number 1 of 1978. And what he did in that plan was, since the Civil Service Commission had been abolished, he transferred all of the Civil Service Commission's authority with respect to the EEO sector and the federal sector programs to EEOC. And he made that effective January 1st, 1979. So that's when EEOC first got authority over the federal sector EEO complaint process. At the same time, his reorganization plan also transferred authority to EEOC under the applicable visions of the Age Discriminant Employment Act that apply to federal employees. So now EEOC was responsible for enforcing those provisions, as well as the provisions of the Rehabilitation Act. And this happened really quickly. So all of a sudden, January 1st, 79, EEOC was responsible for processing all these appeals and making sure that all agency EEO programs are doing what they're supposed to do. And so what EEOC did was it adopted almost in whole the Civil Service Commission's regulations and just put them in another part of the CFR. So they then became 29 CFR, Part 1613, not 1614, 1613. And that's what they had to do. Now, when I came on board in June, which was 6 months after this Office of Review and Appeals had been established, And in addition to inheriting a number of employees from the Civil Service Commission who had been working on appeals and had been working in the federal sector and came over to EEOC, we also inherited a backlog of approximately 5,000 appeals. So with all that work and then new appeals coming in the door, there really wasn't a lot of time to focus on the regulations, which is why it was easier simply to adopt them. They had been working to an extent, and the easiest thing was to adopt them, look at them, see what changes we wanted to make. So now let me talk about the evolution of the regulations once EEOC had the authority in the federal sector. In 1980, 1613 was revised to allow agencies to award attorney's fees and costs. And this was due to judicial decisions which had stated that agencies were liable for attorney's fees and costs. In 1983, they were again revised to allow for, to implement the mixed case process. And we did this in conjunction with the MSPB. And hopefully you're familiar with the mixed case process. And that came about because of the Civil Service Reform Act. When they created the MSPB, they said, okay, MSPB, you're responsible for adjudicating personnel actions appealable to the board. EEOC, you're responsible for adjudicating purely EEO complaints. But when it comes to appealable actions that are coupled with allegations of discrimination, we think MSPB and EEOC should have concurrent jurisdiction. And that's how that whole mixed case process came to be. And so, as you know, a person who challenges an appealable action and then couples it with an allegation of discrimination can go directly to MSPB by filing an appeal. They can file a complaint with the agency. The agency has 180 days to process it. There's no hearing at the agency level, and then it goes over to the MSPB. And you can do one avenue or the other, but not both. And in both cases, once the MSPB has issued a final decision, you can petition EEOC for review of the MSPB's decision, but only on the allegation of discrimination. And that's why my office, when I first started, was called the Office of Review and Appeals, because you had petitions for review and you had appeals. And you had people who worked on reviews, and, the petition for reviews, and people who worked on the appeals. All right, what other changes? We made some minor changes in '87, trying to, in effect, catch up. There were some holdover rules from the Civil Service Commission that no longer made sense. We were also trying to fix some time limits and deadlines so that the process was more efficient. And we did this again in 1992. The most significant thing in 1992 was 1613 was abolished and it was replaced by 29 CFR 1614. But a lot of the stuff that was in 1613 was carried over to 1614. The last major change prior to this most current one occurred in 1999. And I would say the two most significant changes there were prior to 1999, when an administrative judge issued a decision in an individual complaint. That decision was only a recommended decision. It went to the agency, and the agency could either accept it, reject it, or modify it. And once the agency did that, the complainant could appeal whatever the agency had done to the administrative judge's decision. With the change in regulations in 1999, the administrative judge's decision became final. And if the agency was not prepared to implement it in full, the agency had to issue an order informing the complainant that it was not going to implement the decision in full, and at the same time it had to file an appeal with the EEOC as to those aspects of the AJ decision with which it disagreed and with which it was not going to implement. The second major factor, or second major provision in those 99 regulations was the introduction of alternative dispute resolution. That became mandatory in counseling and then during investigation and any other part of the process prior to the hearing, that an agency must afford a complainant under appropriate circumstances the opportunity to engage in alternative dispute resolution. And so that brings us to today, to the recent revisions we made. I just want to point out, as Dexter said, these revisions become effective September 24th of this year, so in less than a month. And let me run down the major revisions very quickly. First, EEO programs must comply with Part 1614 and the management directives and bulletins issued by EEOC. EEOC now has the authority to review agency programs for compliance, attempt to obtain compliance, and then issue a notice to any agency we find is not in compliance with the regulations. Agencies now can, with prior commission approval, conduct pilot projects that differ from the standards of 1614 or the procedures of 1614. You can try other methods of processing complaints. There is only one requirement in adopting a pilot project, that complainant participation must be knowing and voluntary. As long as that exists, you can come up with any kind of idea you want. Not to say that it will be approved by us, but you can certainly try different things. And I should mention that one of the things that's going to happen is Office of Federal Operations is going to revise Management Directive 110, and there will be guidance in there as to what a good pilot project should look like, or the kind of things that a pilot project can contain, maybe even things, it may even say things that it shouldn't contain, but it will give you a good sense of what it is you need in order to get that pilot project approved. All right. Another change now says that any complaint that challenges or alleges that a proposal or preliminary step to taking a personal action is discriminatory, you can still dismiss it unless the complainant alleges that the proposal or preliminary step is retaliatory, in which case you have to accept it for processing. Another requirement on an agency is that if an agency has not completed its investigation within 180 days, including any extensions, and sometimes it's automatically extended if the complainant adds another allegation. You can also get an extension with the complainant's consent. But once you've reached that deadline and the investigation is not completed, the agency must give the complainant a written notice that the investigation is not completed. It has to give the complainant an estimated date of when the investigation will be completed, and it must give the complainant notice that the complainant has an immediate right to request a hearing or file a civil action. What I would suggest, given that this regulation goes into effect on September 24th, is as of September 24th, you have your notices ready, because what's going to happen is you're going to have a number of complaints that are pending, and you're going to have a number of complaints that are pending at the investigative stage. And of those pending complaints, you're going to have a number that have exceeded the 180-day period, plus any extensions. So on September 24th, you are going to have to issue these notices to any complainant whose complaint is pending and where the investigation has not been completed within 180 days. So if you go look at all those complaints now and try to anticipate which ones will still be pending and be untimely, you'll have your letters ready, and you can issue them to the complainant right away. And then that way you won't fall behind, and then you can stay ahead once other complaints come through the system and they haven't been completed within the 180 days for the investigation. We made a revision to class complaints so that the AJ's merits decision on a class complaint is now a final decision, same way it is on an individual complaint, which the agency can then adopt or appeal to EEOC. There's a new requirement that agencies have to submit their appeal and complaint files to OFO in a digital format. Complainants are encouraged to, but they're not required to. there's another revision which applies only to EEOC, and that provision says that when it comes to the acceptance of class complaints, decisions by an administrative judge whether to accept a class complaint, and there's an appeal, OFO will process that appeal within 90 days. Right now, we have a 180-day time limit, so we've reduced it by half because that kind of decision can hold up the processing of the class complaint. We need to know whether the class should or should not be certified, so we're going to do those within 90 days. There's one provision that says EEOC appellate decisions are final for purposes of filing a civil action unless a timely request for reconsideration is filed by either party. This was occasioned because the courts were uncertain when an employee or complainant had exhausted administrative remedies. So what we're saying is administrative remedies are exhausted once we issue that initial appellate decision. And the courts should not anticipate that a request to reopen will be filed or say, oh, I'm sorry, you haven't exhausted because you didn't ask or request reconsideration. There's no requirement. That's optional on an employee's part. So you don't have to ask for reconsideration. We wanted to make that plain so that if the person goes to court and the court says, hey, what about this request for reconsideration? Our regulation now says no. It's final. The person has the right to go to court. We also extended the time in which an agency must provide relief from 60 to 120 days. This, too, is tied into the right to request a civil action. We wanted to make sure that agencies don't have to provide relief prior to when a complainant goes to court. Because here's what happens. When a person gets, even if a person gets a favorable decision, if they go to court and if they're not careful in their pleadings, the court can consider the underlying allegation of discrimination on a de novo basis. They're not bound by EEOC's decision if we issued one in their favor. Now, if they plead it correctly and they go in there with a writ of mandamus and they say to the court, all we want you to do is an order saying, agency, you must comply with EEOC's decision. As a general rule, the courts won't then examine the underlying allegation or the merits of the underlying allegation. But if you don't plead it that way and they just file in court, some courts do. And when that happens, and if the court, say, for example, decides there was no discrimination, the agency's now in the position of where it has granted relief, and now it's going to have to try to get that relief back from the complainant. So that's why we extended the time to grant relief from 60 to 180 days. And finally, we put in a revision just to make a clarification of the difference between breach of settlement and breach of a final decision. If an agency finds discrimination, awards relief, but then doesn't follow through on that award, you can come to the commission and we will order the agency to provide relief. But in a settlement, the complainant has two options. They can come to EEOC and say, order the agency to comply with the settlement terms, or in the alternative, put the complaint back to where it was when the settlement was reached. In effect, restore the status quo. And so we wanted to make that distinction because there was some confusion on that. And as I just wanted to point out, the regulation, these Q&As, which I think are very good, are on our website. MD110 is in the process of being revised. There are work groups working on it now as we sit here. And that will be out. Well, first, once it's drafted, it will be circulated to all the agencies for input. Once we get the agency's comments back, we'll then finalize it, and then it'll become final itself, and it'll be on our website. So now I'm ready to take questions.
We're going to use the microphone because this is being recorded. See the chilled in the room when I said that? This is being recorded.
I have two unrelated questions. The first question is, it doesn't appear that there have been any changes at the very beginning when they talk about the coverage to include sexual orientation and gender identity? That's my first question. And the second question is if there's any clarification on mixed case processing, and since it doesn't appear to be in the regulations, if the MD, I guess it's still going to be 110, could clarify that so we know exactly how to process and what notice, when we have to provide notices, when we have to finish investigations. There's still confusion about that.
Okay. Well, on the sexual orientation and sexual identity, the Commission has issued policy guidance on this. And in the Commission's, what the Commission has said is that if someone thinks they've been discriminated against based on sexual identity, sexual orientation, they can file a claim of sex discrimination, and we will process it as a claim of sex discrimination. So we haven't, there's no statute which specifically says those bases are protected, but in the Commission's decision, in the Commission's opinion, those kind of issues do fall within the realm of sex discrimination. So those are covered. And if you have a complainant who raises those allegations, and let's say you're part of your counselor or you're an agency official who decides whether to accept the complaint, you should counsel the person and allow them to file the complaint and accept it, and then deal with it on the merits and see whether it really does constitute sex discrimination. And one of the things I'd suggest is go, and I don't have it here, but it is on our website, our view on this issue. As to MSPB, I'm not quite sure what the answer is there. I'm not in contact with the people who are working in the work groups. There are a number of them, and I don't know if this is an issue for them. I will certainly raise it. I mean, I know people who are on the work group, and I will raise it to see whether they believe further clarification is necessary for mixed cases. If you have some issues in particular, what I would suggest is email me, and I'll bring them to the attention of the work group. My email, by the way, is it's Gary, Gary, dot Hozempa, and that's spelled H-O-Z as in zebra, E, M as in Mary, P as in Peter, A, Hozempa. Gary.Hozempa at EEOC.gov.
And Gary, just to provide some context in terms of 110, we are revising 110 to incorporate the new rule changes, but we will be updating portions of 110 that needs updating. So if you send Gary or someone an email, it will be considered. Nothing that would modify the regulations, but anything that would help clarify existing regulations is something that we're looking at in terms of MD110 updates. Just let me see the hand so I can get a cue.
Okay, this is a couple of questions. In terms of digital submission, what kinds of things are acceptable? I know there's a mention of CD format. Are there other formats?
Yes. Now, again, this is going to be spelled out in MD110, but my understanding now is that Office of Federal Operations already accepts submissions on CDs. Password-protected files that are put on a CD, and you can then mail them to OFO. They also accept, we also have a portal that's designed to accept digital submissions. And you would have to contact OFO to find out how to access that portal. I also know of agencies that make their files available on their own websites. They're password protected. They provide OFO with the password, and then we can go and retrieve them from, they upload them to their website, and then we go retrieve them by using the password they give us. And those are the ones I'm aware of off the top of my head. And there probably are other means. We wanted to make it as flexible as possible. I think the preferred method will be this portal, and hopefully all agencies will be able to use it, but I don't know the ins and outs of it.
Okay, now in terms of giving a copy to the complainant, does that have to be done digitally as well, or how's that going to be handled?
Yeah, the answer is no, and because the regulation only provides that digital submissions be made to OFO. However, if the complainant is capable of receiving digital submissions, and if the complainant agrees to do so, EEOC does not have a problem with an agency doing that. But you have to realize, not every complainant has a computer or has a means by which it can read a digital file, so they may be limited. And so you will have to provide the complaint with a hard copy. You can certainly ask them if they're willing to accept a digital submission. If they say yes, feel free. We don't have a problem with that at all.
Yes, I have a question about dismissing a complaint that challenges a proposed action. I have two questions. Curious as to the history and how this bubbled up. That's question number one. Question number two, if an agency has already accepted a basis challenge of a proposed action and they accept it under a hostile work environment or tangible employment action, is this retroactive? Is this, you know what I mean?
This is interesting, and if you look at the questions and answers, we do discuss some of, in the context of the effective dates, and this, I think this is the last question in that Q&A, how these regulations will come into play with respect to pending complaints, new complaints, prior complaints. Now, this thing about proposed actions alleged to be retaliatory, the Commission's position is that that has been Commission position before this regulation was issued. We have OFO decisions that state that agencies must accept these types of complaints that allege that a proposal or a preliminary step is retaliatory. So therefore, if you haven't been accepting them, you should have been accepting them because there is Commission precedent out there saying you should do so. So it's not a question of the regulation being retroactive so much as that this has been the Commission's policy since Burlington Northern, the Supreme Court case, was decided, and that was decided in 2006. Now, Burlington, I don't know if, Burlington Northern, I'll give you the site, it's 548 U.S. 53, 2006. And what Burlington, and in Burlington Northern, what happened, what Burlington Northern said is that with respect to retaliation, what can constitute retaliation is broader than what can constitute discrimination. And that what it really comes down to is whether whatever the employer has done has a chilling effect on an employee's ability or willingness to file a complaint. And so if an and what Burlington Northern even went further and said, it doesn't even have to be an employment-based action. You could have a supervisor, for example, who makes crank calls to a complainant at their home. That has nothing to do with the workplace. And yet the Supreme Court has said that type of action could be retaliatory because it could dissuade a reasonable person from exercising his or her EEO rights. And it all, context matters, much like it does in sexual harassment. But that's the basis of why we went this way in our regulation, why we went that way in our appellate decisions. And this has been our policy since Burlington Northern was decided in the private sector. So we have been applying Burlington Northern in the private sector since 2006. And what we wanted to do is say the same protections enjoyed by private sector employees should be enjoyed by federal sector employees. We saw no reason to distinguish the two. So again, you're looking at the proposed action. Does it have, would it affect a reasonable person from, or dissuade a reasonable person from exercising his or her EEO rights?
Do we have any idea when the MD110 revisions will be finalized?
I do not. I know they're working on it. Dexter might have some information, but
The MD110 revisions we'll probably have, our goal is to have it out for public comment by sometime in early November. And so from there, then it goes to the commission for a commission vote. So you will see some version of a draft in November. And we will have stakeholder meetings similar to this one on the draft so we can get comments and input from the public. So we'll have at least 2 stakeholder briefings in November, probably at the beginning of November and one at the end of November before Thanksgiving. Okay.
Hi. With respect to the regulation that now is going to require notice if the investigation isn't completed within 180 days, will that notice still have to be sent out in cases where the complaint was amended during the course of the investigation?
No. What the regulation states is that it includes any applicable extensions. So if a person amends their complaint, if I recall the regulation correctly, it then states that the investigation must be completed within 360 days. So if the investigation, if that occurs, the person amends their complaint, the investigation hasn't been completed after 360 days, that's when you send out the notice. And the regulation states that. It says at the end of 180 days plus any applicable extensions. And also the complainant can agree to an extension of up to 90 days. So but prior to when the 180 days expires. So if you get that agreement from the complainant, now you're looking at, what's it come out to, 240? If my math is correct. It might not be. 270, that's right, thank you. So then your trigger date would be the 270th day. Yes, ma'am.
Yes. A clarification on the 360 to complete the investigation. Does that mean that we would actually have the report of the investigation in hand by that deadline, or just to have completed the actual investigation itself?
What we contemplate is that you are going to give the employee the report of investigation, that it's ready to be handed to the person. Now, I'm saying that, but again, you may get a different instruction in MD110, so I don't want you to hold me to that. My understanding is that that's what was contemplated when the regulation was drafted. Now, it may be after this work group goes through the MD110, they may say, well, if they can certify it's completed, and now all they have to do is type it up and everything, that will be sufficient. But I don't know. Right now, as it stands, my understanding is you're ready to hand it to the person.
Yes, I just wanted to go back to the question about the confusion concerning mixed cases.
Yeah.
And I wanted to make sure that we have a consensus about what that confusion is. The problem, as I see it, is because MSPB, throughout the ability for us to do any type of analysis based on Bivens and whether these claims were inextricably intertwined. So what happens is we're dealing with what would have been the pure MSPB matter and what could possibly have been like tangential issues and so forth. We're sending those to EEOC while the pure MSPB matter stays at MSPB, but everything really is inextricably intertwined. So I think for myself, the cure would be for that doctrine to be resurrected, but I know that's probably not likely to happen. But isn't that what you were talking about? Is that what you were referring to with needing clarification? Oh, okay.
Well, that's part of it, and that's actually why, but the issue was that years ago, we used to believe that agencies had to issue their final agency decision or final decision at 120 days after filing, investigate, and then 45 days to issue the decision. Several years ago, we got guidance from EEOC that no agencies, you misinterpreted that, you process mixed cases like all other cases with some exceptions, meaning that you have 180 days, or if it's extended to 270 days, to issue the ROI, and then you have 45 days to issue the FAD after that. There's no request for hearing, obviously. But at 180 or 200, at 180 days, no, 120 days, we had to issue notice of the individual's right to go to MSPB.
Oh, interesting.
And that's where the confusion
Okay.
was.
Yeah, I'm not aware of that. If that's the case, then
I'm not
that's
sure about
something
that
that has occurred after I was dealing with mixed cases. You know, my understanding always was the agency had to issue a decision after 120
20
days.
days.
If, so I'd have to go back and see or find out whether OFO has somehow modified that, although I don't see how they can. Well,
Yeah,
I
that's,
don't
it's
know.
regulatory. So I mean, we could talk about that offline because it's 120 days to complete, because you're talking about the board's process. That's their process for dealing with a mixed complaint. But
as
Benita's
to-
question is
Well,
good, but I would rather put it in writing because it doesn't really, it's not in this reg change. That's something
Right.
that maybe can be clarified through the, analysis of a case. And we will, update the management directive if there's a case that revises it.
Yes, because that is really a complex issue, and I know what you're talking about, where the MSPB might say, well, listen, we're dealing with the appealable action, and this other stuff over here isn't appealable to us, so we really don't have to consider it, even though it might be probative of whether the appealable action was discriminatory. And how do you deal with that? And maybe that's going to require more coordination between EEOC and MSPB. I don't know, so.
Can you define what it means by distinguishing appeals alleging breach of settlement agreement?
Say that again, please.
In there it says a revision which distinguishes appeals alleging breach of settlement agreements. What does that mean?
Well, what happens is a complainant and an agency settle a complaint. And so there's no final agency decision, there's been no appeal to EEOC, and let's say the settlement agreement is that the agency agrees to promote the individual within 60 days. 60 days goes by, 60 days goes by and the person hasn't been promoted. They then have the right, under our regulations, to appeal to EEOC and allege breach of settlement agreement. And when they do that, EEOC can order relief in one of two ways. It can either order the agency to comply with the settlement agreement, you agreed to do this, so go do it, or if the complainant prefers, it can order that the initial underlying complaint be reinstated at the point processing ceased when the settlement was reached. So in effect, you just go back to where, we null out we make the settlement null and void, and now you're back in the EEO complaint process pursuing your complaint.
Okay, so that means that the complainant can go right to EEOC. They don't have to go to the agency and say, my settlement agreement's breached.
They are supposed to go to the agency first. Right. That is under the regulation as well. And I should have, so let me correct myself. They should go to the agency first and say, you're not in compliance with the settlement agreement, you need to be in compliance, what are you going to do? And then if the agency says, it depends what the agency says. If the agency says nothing, after a reasonable period of time, the person can file an appeal with the EEOC, and we will most likely accept that appeal if the agency is silent. I mean, the person isn't expected to have to badger the agency for a response. Usually the agency will respond, and they'll say, okay, it's taken us longer, we'll do it within 90 days. If the complainant's willing, and even then, the complainant can still appeal to us. I'm not sure what we would do in that case, especially if the person's then promoted within that 90-day period while his appeal is pending. Then we would just moot it out, but that's how it's supposed to work. First go to the agency, and if you don't get satisfaction from the agency, come to us.
Any other questions? Todd works in the Office of Federal Operations, so.
Yeah, but I don't see Gary that much. So I guess my question is you're saying the regulation says that the complainant has a choice of asking for either compliance or getting their complaint reinstated, but I assume that, I didn't read the revised regulation recently, but you're saying it draws that distinction in the revised reg, right?
Yes.
And so is there, when the cases come up, I was wondering whether there's some anticipation that OFO can weigh the equity. So for example, if you have a settlement agreement with 3 or 4 things, one of them is the complainant got $10,000, and but he got his promotion in 90 days versus 60, let's say. Can we look at is the regulation saying we can't look at the equity, we have to follow what the complainant says? Or can we, well, geez, he got the $10,000, it was 30 days late, we're going to just say implement, because that's more equitable? Or no, whatever the complainant asks for, we have to just
Right.
be like a robot and do that?
I'm not sure what the answer is. I don't know, because that is really a decision for the Office of Federal Operations to make in a given case. And it may, you know, when I went to law school, and I remember this professor saying, and I'll never forget it, he said, you know, in law, there are no absolutes. For every rule, there's an exception, and then there are exceptions to the exception. So you never want to say, yeah, this is the way it's always going to be, because you never know. The right case comes up, OFO may well say exactly what you're suggesting, that, you know, we're going to overlook the fact that they took 100 days rather than 50 days, because in the end, the complainant got what he got. On the other hand, they may say, no, you know, 50 days means 50 days. I don't know. And I think that has to await OFO, since that's going to be their call.
It kind of seems to me that we're making more out of the problem than needs to be, because if that were to happen with our situation, I would simply suggest that the complainant be given a notice that we're tardy in getting this done, but it's going to be retroactive to the agreed-upon date.
And that's a very good point. Let's say it is retroactive promotion, and they wait 180 days when they're 100 days when they were supposed to do it in 50. Clearly, the complainant is entitled to 50 days of back pay, because they were supposed to do it in 50 days, they waited 100, and if they appealed to us, it would make sense that we would say, okay, this is fine, except for the fact that agency, you now owe him 50 days of back pay, because you didn't keep to your promise. And yes, so that would make perfect sense. And again, and this whole other section was just also to make clear that when it came to, and this would happen, when it came to final decisions on the merits where relief was ordered, some people were thinking, oh, if the agency doesn't comply, you have to reinstate the complaint. The answer is no. The complaint's over, done, closed. The only option at that point is agency, give the person what you awarded them.
I know you said you didn't know a lot of the details about the portal access, but I believe our agency, some of our complaints processing personnel have requested passwords and have not heard back. Well, do you know if those will be issued before September 24th?
I do not. I know the portal is, there's interaction with our Office of Information Technology, so it's the OIT people who do that. And so, you know, when it comes to the portal, other than knowing it exists, I don't know how it works.
Gary, she couldn't have honestly thought you were going to answer that. When would the passwords be issued? But we have the portal we have is a FedEx, I mean, it's the federal sector portal, and a part of it you will see from the design is going to be, it's an open portal where you submit your complaint files, your 462 data, MD715, so you have different options. So if you're submitting complaint files, you'll go there, you register and get a password. Our person there, I mean, you can give me your information out there, so we'll make sure that the folks get access. We piloted it with several agencies, and we'll have it ready and live in the next couple months so that agencies can meet their time frame for the electronic filing.
Oh, you know what, and I just wanted to, you know, I don't want to keep you, this will be very quick. When I first started in Office of Review and Appeals, you know, you go through these complaints, and I had a special way of reviewing the appeal file, and I'd start with the complaint to see what the complaint was about, and then go from there. And if it was unclear, I'd then go look at the counselor's report, and then go look at the investigation. So, I'm about 2 years on the job, and I get this complaint, and back then, and it may still be the same way, but you have a complaint form, and there's a section where you can check the bases, and this person had checked the box for race. And next to race, there was always a blank space where you could write in what race. So you could put white, African American, Asian. And this guy had written in human. So I'm looking at it and going, well, this is kind of cool, because I've never had one where it was discrimination based on the human race. And so I said, well, what's this about? So I go, and on the complaint form, you know, down in the middle, there was a blank space where the person could write his allegation. And he had this sentence, one sentence. It said, My boss treats me like a dog. And so I'm going, I can't believe the agency accepted this complaint for processing. You know, and so what's going on? Looking at the counselor's report, it's not shedding any light on this matter. And I look at the investigation, and as I'm going through the investigation, I finally get to the supervisor's affidavit. And the supervisor, like the complainant, has one sentence, and it says, "What does the complainant expect?" Or two sentences. "What does the complainant expect? He's an animal." And so I just thought that was my favorite all-time complaint.
Back to digital submission.
Yes.
I assume that applies to submissions where there's a request for a hearing before an AJ as well as appeals to EEOC?
Well, if the regulation as written only applies to the appellate stage. It does not apply to the hearing stage. However, our AJs would not object to receiving electronic or digital files. And agencies might think that's an efficient way to do it, since what you give to an AJ, almost all of what you give to an AJ is going to have to be given to us when an appeal, if and when an appeal is filed. So if you get that into an electronic or digital format at the appeal stage, then you're ready to go if and when an appeal is filed. So we will accept it. But given how the regulation is written, it's not required.
And during 110, we may explore expanding on that with a little bit more detail. Okay. Any additional questions? Benita, look at her.
It's not really a question, just a comment with regard to the fact that the hearings are being digitized anyway. There's a pilot underway.
Yes.
And, yeah, and it's really, we had one of your judges from the Miami District Office, Joy Helprin, I think is her name. She has a really good PowerPoint presentation. I don't know if you all can make it available to everybody, because well, the reason why I'm saying it's really good is really interesting, because for some of us who are trying to come up to the 21st century anyway, when we hear digitized, we just think, okay, it's got to be digitized, but there's some very specific things that you have to do in terms of even making certain that your pages aren't numbered as we've been numbering them traditionally, and you have some instructions that you may have to give to like contract investigators and that kind of thing. So if you all are doing this with regard to appeals and people are already starting to do it for hearings, I think that some of the information or some of the instructions that they give about exactly what you have to do, all the specifications related to digitizing, should probably be more widely disseminated among everybody, especially, like I said, for those who may be, you know, dragged kicking and screaming into this 21st century.
No, that's a good point. And Gary's nice. I'm responsible for the revisions of 110, so I can speak that we have a work group with folks from legal counsel, administrative judges. We have an administrative judge from Miami. And what we're going to do is explain the digital filing, what's required, but also, you know, lay out the benefits that if you do it during the hearing process, you won't have to do the same thing during the appellate process, except for the addition of the record that was created during the hearing would have to be submitted. So all that'll be in there. It'll be a holistic to address EEOC as a whole. Everyone that you mentioned, Joy Helprin and her supervisor in Miami, are part of the work group. So it's going to be a collaborative effort. Right. Oh, one more question, because I think we're approaching our conclusion time. So this will be our last question. Make it good.
I hope it's good. I was wondering if one or both of you could comment on the first requirement under number 5, which is that the requirement that the EEO, the agency, complies with the management bulletins, the directives, and that sort of thing, and how that works with the APA and the notice and comment provisions. And does that somehow conflict with the notice and comment provisions?
Okay. As to that, if you read the preamble, what we did is we addressed it, because when the notice of proposed rulemaking went out we did get comments from the public raising the Administrative Procedure Act argument. And then when the final rule went out and we submitted it to OMB, and OMB did its interagency coordination, we received additional comments from agencies having to do with the APA. So we addressed that argument in the preamble. And in essence, and one thing I wanted to mention is when President Carter was issuing his executive orders and doing his reorganization plan, he also issued what's called Executive Order 12067. And that executive order requires EEOC to coordinate all EEOC initiatives with affected agencies. So before something like MD110 is final, we will have to circulate it under Executive Order 12067 to all agencies. And they will have an opportunity to comment on the content of MD110. And we will have an obligation to consider those comments before we finalize the document. So to the extent agencies are worried about notice and comment on any future documents we issue, there will be a notice of comment. It won't be under the Administrative Procedure Act, but it will be under the executive order. And we will treat it, we will treat the process the same way, as if we had submitted it for public comment. We're going to submit it for agency comment. And look at those comments and then decide whether we need to make some changes. So that's our response to that concern.
That was the last question.
I have a quick question. Just can you tell us-
Wait a minute, you gotta get the mic. I'm afraid after your last question saying the EEOC revised MSPB's regs, I'm nervous.
Thank you. No, my quick question is, where may we find or can we find these Q&As on the website? I presume OFO, but
It's on our website. I don't have it up. I could put it up, but it's, where's Denise? Because she left. But it may be on the homepage in the scrolling section, but there's a tab that says federal agencies. So you'll find it there, and I'm not sure what tab, but it's linked to the regulations tab? Okay. So if you go to the laws enforced by EEOC, and that's at the top of the homepage, then there's sections that says laws and regulations. Click on the regulations, and then usually on the side, there'll be useful documents that relate to that topic. And if you have any trouble, just email us, and we'll guide you to it. Okay? Well, I want to thank everyone for coming out today, and I want to thank Mr. Gary Hozempa for outstanding presentation. And I hope you enjoy the rest of your day.